Welcome back to Navigate Your Wealth. I'm your host, Kristen Oakley, here with both Karen and Sam from Compass Financial, based right here in Charleston. We are having a really heartfelt conversation today about all things estate planning because we want to make sure that your affairs are in order. I want to circle back to that client story that you shared. Of course, the client was the daughter who was dealing, unfortunately, with a mess from her deceased father that he unintentionally left behind. Let's talk a little bit more in depth why probate is so problematic.
It's expensive. Here's the thing. If you own a home, and let's just say it's a $750,000 home, and you only have $100,000 in it, so you have a $650,000 mortgage, the probate is based on the full value of the home. They don't care that you really only own $100,000 of it. So the probate fee is based on the entire $750,000. So that's number one problem. The other problem with not having the estate plan is just the control from the grave, right? When you have everything in a trust and you say exactly how you want it to go, maybe in this particular situation, he wanted one daughter to have more than the other daughter, they can contest wills. With a trust, they can't contest it. There's provisions that you can put in it so that they can't contest it. So it just gives you a lot more control for what you want to see happen.
Yeah, and this is so important because a lot of families maybe are dealing with an adult child with disabilities who's going to need a certain kind of care. Maybe you have, unfortunately, we see this too, folks have a child who's a spendthrift or who's dealing with an addiction. You can have that control within the trust to make sure everyone's taken care of in the right way that meets their needs.
Well, and more to that point, when we first did our trust, Samantha and Scott were 9 and 11 years old. And so, I mean, we had, you know, estate, we had insurance, we had everything. And so we set up our trust, and this is the beautiful thing about the control piece. We set up the trust so that should we die earlier than we were hoping, that the trust would get split into two pieces, half for Samantha, half for Scott. And the payout provisions were that at 25 years old or upon graduation from college, each one would get 25% of their half. At 35, they would get 50% of their half, and at 40, they would get the balance. Now you say, well, why would you do that? My experience has been that inheritances of any value are more money than that person had the day before. And typically within 18 months, that money is gone. So by structuring it out that they have to graduate from college or hit 25 and then 35 and then 40, it was kind of 3 strikes, you're out. Now the good news is my husband and I are still here, and they both passed those first 2 mile markers. But the point is that we can write all those provisions into the trust to give you that control of how you may want to disperse those assets to your family.
And it really is about having that control that's so important. Again, this is your money, your assets, your wishes. We want them to be carried out the way you want them to be. One of the things we would also be remiss if we didn't get into today, and it's something that I'm so passionate about, I know you are as well, is making sure your beneficiary designations are up to date. First, explain what those are, and then we're going to go into some details about why it's so critical, right?
So when it comes to beneficiary designation, typically there is the primary beneficiary, and then there's contingent or secondary beneficiaries. These are operation of law. So this is where the law is able to pass the asset to exactly who you want.
And let me just clarify, what types of assets are we talking about? Where do folks typically have these beneficiary designations?
So on life insurance, there's beneficiaries. You can put beneficiaries on your accounts at the bank. You can put it on your
IRAs,
your IRAs,
401ks, right?
Perfect, your 401ks. Any place that you can put a beneficiary designation, you're going to want to include one. Other operation of law is transfer on death. So if you have your name and transfer on death to someone, so if in my case it was the account is in my name and then transfer on death would be to my husband, Jared Irish.
Well, no, go ahead. You say so. Joint account also does that. So what we were bringing up is the ways to avoid probate. Operation of law. There's 3. There's joint tenancy. So if it's joint name, one goes to the other. There's beneficiaries, or there's the transfer on death. Okay, But the other thing with beneficiaries is, and that's the big question about per Stirpes and per capita.
Yes.
So a lot of people don't understand this. If I list my beneficiaries as Samantha and Scott, my two children, I can either list it as per capita or per Stirpes. And the difference is per capita means if something happens to Samantha, everything goes to her brother Scott. But if I say per Stirpes, then if something happens to Samantha, it goes down her line of beneficiaries or her family line, her husband, her children, what have you, and Scott would still have his half. Right. So there's, you know, all these little intricacies that you have to know about, but they are the pieces that, you know, we want to help.
For sure. Yeah, and per Stirpes is Latin for of issue, and in our family, so unfortunately my husband's brother passed away when he was 36, and he had twin boys who were 7. Well, fast forward, I didn't join the family till a good, 13 years later, and when I was first educating my in-laws about this, they didn't realize that they had inadvertently left their 2 grandsons out of the will until I came into the picture and said, we've got to update these beneficiary designations. And what a lot of people don't realize is whoever's name is listed on the beneficiary designation always trumps what the will says. That's another big misconception people don't realize. They think, oh, I've had a will, I'm fine. Well, guess what? If that name hasn't been updated on the beneficiary designations, they could inadvertently be left out of everything.
Well, and that's so important that you bring that up, Kristen, for a couple of reasons. First of all, if you haven't checked who your beneficiaries are on your bank accounts or some of your other assets in a year, I'm telling you, there should be an annual thing. Like, you know, checking the battery in the sprinkler system, smoke detector. Okay. Yeah. You should also be checking your beneficiaries, because here's a story of a client. She was, the wife was my client. Her husband, for whatever reason, it was a second marriage, was not. And we had done all this work with the wife, and I said to the husband, would you like me to just review things, go over anything, kind of give it a, you know, second opinion, you know, look over? No. It's all good, I'm fine, is what he said. Well, he passed away, and what we found out was that one of his old IRAs, he had the first wife as beneficiary. Now, the good news was it was a very small amount, and she was gracious enough to sign it over to the wife, but she didn't have to.
No, she wasn't legally required to.
No, and he said, no, I'm fine. So really checking those beneficiaries is important.
Absolutely. One more time, I know you want to share the special offer that we have today.
Yeah. Listen, we know that creating a trust could be a burden, and we want to give you the opportunity to build your trust package with Legacy Lock for a $500 discount. For less than $1,000, we want you to have the opportunity to put all of your affairs in order so that you get to remain in control. You've worked really hard for your dollars. Let's make sure that they go exactly where you want them. This is the most loving thing that you can do for your family, for your community, and for yourself. Take action today.
Sam and Karen, thank you so much. We love you, Charleston. We look forward to being back with you next time on Navigate Your Wealth.